and we are back sharing knowledge, sharing legal nuggets. By introduction, I am a qualified admitted attorney with a master's degree in commercial and contract law. I am a director of a law firm, City Attorneys, and I'm sharing knowledge with you because it is important that we are well aware. Today we're speaking about dismissal. Have you been dismissed from your job without proper procedure? Have you been dismissed without any valid reason given to you? Or are you as an employer struggling to follow proper process to dismiss an employee who is conducting themselves improperly? Today we are speaking to both the employer and the employee for a better understanding of what really is unfair dismissal in terms of the law. May I put a disclaimer that what we're discussing today is not extensive legal advice. However, you are welcome to speak to lawyers such as Clementina Thai attorneys for further legal advice. Remember, in South Africa, dismissal really is not unfair unless where the employer is unable to prove that there was a valid reason for such a dismissal. There are three categories mainly in which dismissal is viewed as being unfair. One being automatic dismissal. This is dismissal where one is being dismissed, for example, or discriminated on the basis of their gender, on the basis of their race, on the basis of being pregnant. That is viewed as automatic dismissal, for which it's very difficult for an employer to give the grounds for such a dismissal. Unless, for example, in the second category where the employer can prove that it was for substantive reasons that they had to dismiss. For example, where one was pregnant and was unable or incapable of carrying a particular type of job. However, there are procedures that must be followed in that instance, in that the employer must offer to this pregnant employee a different type of work for which a pregnant person would be able to carry out. So under the category of substantive unfair dismissal, we have issues of misconduct where an employer can prove, listen, this dismissal was not unfair because there was misconduct on the part of the employee. One can also prove that there were operational changes as an employer which required that there be a reduction in staff. This happens often so where there are financial difficulties that are incurred by an employer. With all of the above that are mentioned, there must be procedural fairness, which is the third category that we're dealing with, where an employer is unable to prove that they followed proper process. That can be viewed as unfair, procedurally unfair dismissal. For example, an employer can prove really, or must be able to prove that they gave a warning in writing, that they alerted the employee of any misconduct or any change whatsoever that is coming into the business. They must indicate also that there was proper consultation, be it with the trade unions that the employee is part of, or be it with the direct employer where there are no such trade unions. An employer must also be able to prove that there were fair hearings where the employee's side was taken in cognizance, the employee was given a chance to put down their case, more specifically in issues of misconduct. We're rushing through this because this, as I mentioned, it's not extensive legal advice. Remedies. What can you do if you find yourself being dismissed and you feel that it is unfair, or you were not given valid reasons for such a dismissal? Within 30 days, you must submit your application or your query with the CCMA. If you fail to do this within the timelines, you will have a difficulty of applying for condonation. So I advise that you approach your lawyer as soon as possible for guidance in order for you to file your complaint with the CCMA. The CCMA will set up a meeting between the employer known as conciliation, where there will be a discussion of this issue of dismissal to check and to decipher if there was unfairness. If there is no agreement within the conciliation, there will be arbitration and mediation. Following that, only can you then take your matter to the labor court, which is a court that it deals with issues of employment. May I please mention that all of this is in accordance and governed by the Labor Relations Act and the recent 2025 Code of Good Practice for dismissal, which guide how employees and employers have to relate in terms of dealing with dismissal. I hope this helps, and I repeat that please approach your attorneys for further extensive legal advice in this matter because it is quite a complex one. Thank you.